Morning, everybody in class, everybody on Zoom. Hope you're having a good day and you're excited for this extremely boring seminar by an attorney. Well, I'm trying not to make it boring. I'll try to make it fun. Okay, I'm not going to use code sections and I'm not going to use rules. I draw pictures and I tell you about war stories, and I'm hoping in those war stories you'll get to kind of see the situation and how things work. So this class is about completing a real estate transaction when there's a bankruptcy, probate, or trust issues involved. And you can see my house and my little drawing there. I did this with maybe like half a bottle of wine, so it's pretty colorful. Okay, I made changes from the last one though. Okay, so a few important points. My name is Vinod Nichani. I own the Nichani Law Firm. We are on the Alameda in San Jose. We handle business disputes which involve businesses, business interests in trusts and probate, bankruptcy, and white-collar criminal defense, because they're all kind of hand-in-hand business, which is a Ponzi scheme at times, right? So that's what we do. I have a small practice, have a few attorneys and staff, and we mainly cover California, but we do have clients internationally that either need representation here or we represent them in other states. That's my firm. A few points before we continue on the subject matter. I do tend to bounce around a lot. I will say go ahead and ask questions if you need to. Number one, seminar is for informational purposes only. There's no attorney-client relationship here without some kind of engagement. You're not a lawyer or CPA. Don't try to be one because you'll get sued. Just take it for information. Don't go back to your client and try to advise them and get in trouble. People do that. You're here to learn something I call triggers. Triggers are what you in your business look for or listen for. And those triggers are what's going to help you assist your client to maybe seek legal advice. For example, if you realize a client's in bankruptcy, what do you do? Or the owner of the property passed and your client wants to sell the property, but there's no documentation showing they're on title. Or there's a power of attorney. Certain things come up that require legal counsel. Your job is not to advise them. Your job as customer service, you can suggest to them and say, hey, maybe you should talk to an attorney. Maybe you should talk to a CPA. And trust me, AI is freaking amazing. It's great. You can go on there, give them legal advice. But it is wrong at times. It's not 100% right because every situation is different. It's great for facts, but it's not always accurate. So that's kind of a nutshell here. There are real estate agents who try to be lawyers, who file bankruptcy for clients, advise them on trusts. It all goes wrong. So do your client a favor. Don't give them legal advice. Have them seek an attorney. One of the things I advise every business, such as a real estate professional, is communications with all parties involved. You have to take the time to confirm your communications, because those confirmation emails or those communication emails are evidence to me as an attorney if a dispute arises. So if you're talking to someone or communicating with someone, if they're making a statement to you, take a minute, take 2 minutes. I mean, you can dictate an email. It's super fast. Just make the email and send a confirming email. On so-and-so date I spoke to you, it was agreed on this date, this would happen, and have it in a communication form, put that in your file. Because tomorrow everything goes down, I'm going to ask for those emails to support your case or not. So take the time doing that as a business owner. Number 5, build your team. And I'm going to expand on this on one of the examples. As a professional, you want to have a team around you that supports you in the business you do. Find a good CPA, find a good lawyer, find an escrow company you want to work with. Because escrow is the gatekeeper of completing a transaction. You're either going to get paid or you're not. So if I were you, man, I'd be at their door every day making best friends with every escrow company I work with. Because they're the ones that are going to look at the orders from the courts, the ones from the judges. They're the ones that need to smile before you get paid. So build a team. Get to know your people around you. All right. Okay. You can ask questions all day long. I'm not the type that's going to get it. You can ask me questions mid-sentence, raise your hand, throw something at me, it doesn't matter. I'll answer it to the best of my ability, but everybody's questions could be different and require additional investigation to give me an accurate answer. So if you say, hey, I have a question for my friend, that's okay. You can ask me, but I can't guarantee an answer. I may suggest we talk about it after, or I might give you a general answer, but I can't go into too much detail. So that's just something to know. Okay, so the first topic we're going to start with is bankruptcy. All right, bankruptcy is a legal process for relieving debt that a borrower cannot repay. Basically, you're underwater. Your liabilities exceed your assets, okay? There are 3 types of debts: unsecured, secured, and priority. Does anybody know the difference? Anybody know what unsecured debt is? No? Yes? No? Unsecured debt.
Is there a personal loan?
So that's secured debt, right? Yeah. Secured debt is something that's secured to something. If the creditor doesn't get paid, it's security, such as a car, a property, things like that. Unsecured debt is your credit card, right? It's not really secured to anything. If they don't get paid, they're screwed. They'll sue you, but it's not really attached to it. It's not attached to your house or anything until a judgment happens. Priority is an unsecured debt, but carries a higher level, which is like tax debt. That's what that is. Okay? So now I segue a lot. That's just because I usually make an outline. I work really hard on it, but I never follow it. So I'm trying really hard right now, guys. Does anybody know the process of a lawsuit in California, how it works? Okay. So a lawsuit is someone files a complaint. Once they file a complaint, they have to serve it on the people that are being sued. Okay? Once that complaint's served on an individual, that individual has 30 or 35 days, depending on the service, and on state court to respond to that complaint. And responding to that complaint could be various different vehicles. Number one is they could deny everything and say, hey man, I didn't do any of this stuff. You guys are wrong. Another one, they could say, you know what, this complaint is defective on its face. You haven't explained to me this complaint, the basics that are needed to tell me why I'm being sued. I don't understand. Okay, so you can file something like that. Or what could happen is you could do different motions to try to dismiss the complaint, different things you could do within those 30, 35 days. After those 35 days, if you've responded, such as denied everything and answered the complaint, then something is called discovery. This is the process of both parties conducting discovery to find out what defenses they have if they're being sued, or what evidence they have to prove their case. Okay? That's discovery.
If you're walking away, can you take the mic with you? Because people on the Zoom are having a little trouble.
Oh, sorry, Zoom people. Okay, here you go. I kind of feel like a singer right now. So, okay, so you know when you're on, where was I? Okay, so discovery. Discovery is the process of developing your case. During that time, that's where depositions are done. That's where questions and answers for paperwork are done. And then you build your case, build your case, build your case, and you get to a trial, okay? At the trial is where the winner gets a judgment. That piece of paper is what they could use to collect on the debt. So if the plaintiff is suing and he gets that judgment, he or she now has a piece of paper that's worth $1 million, $2 million, $500,000, doesn't matter. But guess what? It's only a piece of paper. So what's the value of a judgment if you can't collect on it? Does that make sense? So if you got a judgment, then the question is, okay, now I need to collect on this judgment. So they can do various things. They can go ahead and find bank accounts. They can find assets, lien properties. They can call that individual to court to conduct an examination of their financials. Okay, that's how they find the assets. That's called a creditor. They become a creditor. Okay. Now these different types of debt, you have unsecured creditors, secured creditors, priority creditors. These are all people that are creditors that need to collect from the debtor. The debtor is the individual or company that files the bankruptcy. Okay. So in the simplest form of things, you have a bucket of debts and assets in bankruptcy. You have the creditors that want to get paid, and you have the debtor saying, look, this is all I got. I can't pay you everything. Again, within that general understanding, the next step is the opportunity of bankruptcy for a debtor. Okay. If I'm going too fast, let me know. If I'm not making any sense, let me know. Okay. Oh, it says it right there. See, I drew that. I talk fast. Let me know if you want me to slow down. Okay, different chapters we talk about today. Chapter 7, Chapter 13, and Chapter 11. Chapter 15 is not really relevant for today. Chapter 7 and 13 are probably the most relevant. 11 does come into play because of the asset value in the Bay Area. Properties are expensive. Debt is high. Loans are high. Okay. Chapter 7 is the first bankruptcy we're going to discuss. Chapter 7 is called a liquidation. That means I don't have anything. Take everything I got and let me go. So what is the process of filing a bankruptcy? Okay. Most individuals, so for example, let's say your client has a foreclosure date coming up in a week, and you're going to say, well, okay, why don't you talk to an attorney? So they call the attorney and they say, hey, you know, attorney, I have a foreclosure date in a week. I really want to stop this foreclosure. What do I do? So in most cases, this individual would go and have a meeting with the attorney. Okay, it'd be an initial consultation. The attorney would ask for financial documents such as bank statements, title to property, mortgage statements, car statements, something to build the whole financial picture of this individual. And then the other side, it would be the debts. You know, I'm sorry, the assets. What assets do you have? What is the value of your house? What's the value of your car? Do you have a lease? This whole financial picture has to be provided to the attorney. The attorney digests the information and he prepares a bankruptcy petition. Okay, the petition is a stack of paper. The first few pages are, you know, name, information, social security, statistical information. The next pages are all assets and debts. Then it goes even deeper. It asks you about transfers. Did you transfer your house? Did you transfer your car? Did you transfer any money? Did you move anything around? And that's where people get caught because they try to transfer stuff before filing bankruptcy, thinking no one's going to find them, which, you know, that never happens. So people do get caught for transferring assets. Or people get sued in a bankruptcy for fraud. You know, if I give him $100,000 saying, hey, I'm going to give you $100,000. Sorry, you're going to give me $100,000, and I'm going to invest that $100,000 for you into property A. But instead, I take the $100,000, go to Vegas at the Wynn, and blow it. And I knew I was going to do that. You know, I knew I was going to blow his money. I was hoping to make more money on the tables, but it didn't happen. So guess what? I just committed fraud. I lied to him. He can go into bankruptcy court and he can say, hey, wait a minute. That is not truly a debt. That's a debt that was taken via fraud. And therefore, the bankrupt individual cannot run away from the debt. And that's called an adversary proceeding, which is a lawsuit in bankruptcy court. So those, I've been seeing a lot of those lately, especially when you have the complex bankruptcies that involve like Ponzi schemes or flipping or properties. I mean, it's sad because a lot of people collecting investment funds really have this pie in the sky dream that they're going to do so much good business with properties, but then they realize they can't do it and they're stealing money from Peter to pay Paul, and that intent changes because now they're trying to continue living that high-end life with investment money. Yes, sir?
I remember there was a bankruptcy law changes before.
Mm-hmm. Mm-hmm.
Before, anybody can just file Chapter 7, but now no more.
Right. So 2005, I think. So, yeah, anybody can file bankruptcy. That's not the question. Anybody can file. All you need to do is press a button on a computer and electronic file bankruptcy. Your attorney just does that. It's in like 5 minutes it takes. But the question is whether or not you will receive the benefit of that bankruptcy, right? Whether you get a discharge. If it's fraudulent, you may not. Or whether or not you can come up with a payment plan that the creditors approve. So that's kind of where the details come in. But filing bankruptcy, yes. Whether or not it's going to stay and get that component is the other question. But yeah, the rules changed, and it became very detailed in an analysis, and it looks at your median income, how much money you make, what have you transferred, how much assets, like did you pay Amex over Visa for some reason, why isn't everybody shared equally? There's different issues that come up, okay? So Chapter 7, and you know, I'm giving you guys really basic kind of overview of the bankruptcy stuff. I mean, these things are by no way that simple. So Chapter 7, liquidation. Okay, simple analysis. If the individual has assets of $50,000, okay, and there are things called exemptions. Exemptions mean that that asset is protected to a certain amount. So there's various exemptions. It could be $20,000. It could be the homestead exemption of up to $700,000. It just depends on the state and the code section that's used. But for example purposes, let's, for example, say $30,000 is the exemption, okay? So that basically means, you guys see that? Okay. What that means is $50,000 cash, exempt $30,000. There is, oh my, okay, that just shows you my math sucks. Lawyers can't do math. So that becomes actually a $20,000. So $50,000 cash, protecting 30. $20,000 is available to pay the creditors, okay? Now, the same individual has $100,000 in credit card debt and $60,000 in medical bills. That provides for $160,000 in debt. Follow me so far? Okay. So what that means is these creditors have to share in this $20,000. So basically they get a percentage of their debt. They don't get all the money back. So how this would work, how Chapter 7 would work is your attorney would file your bankruptcy schedules and items. There'd be something called a meeting of creditors. A meeting of creditors is where a trustee is appointed. The trustee is an individual whose job is to investigate your assets and liabilities to find money. And from that money, he or she takes a percentage, and the rest goes to creditors. So in this case, what would happen is the trustee would investigate this 50,000 cash and say, okay, where's the money? How's it held? She'll look at the exemptions and say, okay, there's 20,000 bucks, and she'll take a big chunk out of it because that's what they do. So, and then the remainder would be shared with the unsecured creditors. And that whole process takes about, I would say, 3 to 4 months if it's pretty simple. But the goal is that the bankrupt, the debtor wants a discharge, and that's where they could discharge the remainder of the debt. So that's a Chapter 7. So it's pretty simple.
I think my question actually is some clients, they file Chapter 7 specific to the real estate property, not on their other creditors. Are they able to do that, right?
Well,
Because they're not defaulting.
you can't pick creditors. So what they do is they file Chapter 7, but the only way they can file Chapter 7 on a property, or the only reason they would, is number one, if they're going to file on the property, they have to make sure their equity is protected in a 7. Otherwise, they lose the house. Yes, sir. Oh.
And somebody asked a question in the crowd, can you just briefly repeat it so they can hear it?
Oh. How about I walk to him and have him say the question?
That would be, no, I have another mic.
Oh, that's a cool idea, huh?
Here,
All right.
I got it.
You just got all the attention on you now. What's your question, sir?
Well, the question was, people file Chapter 7. The question is specific to real estate property only without regard to their other unsecured loans or other credit. They just want to protect their property. Can they do that?
They can file a Chapter 7 and protect the property, but the property is only protected if the equity is protected by the homestead exemption. Then the 7 all would do is, it wouldn't really do anything. What's it going to do for the property? They might be able to avoid a judgment lien. Well, they can protect it in a 7. Any bankruptcy is going to stop a foreclosure. But when you file Chapter 7, the assets don't belong to you technically anymore. They belong to the trustee. So if the house has no equity, the trustee lets you keep it. If the house has equity, they're going to tell you, you got to pay me the equity to keep the house. So for example, if we go back to this same example here, and let's say there's a car. I'll make it simple. There's a car that's worth about $25,000, okay? And the car exemption is $5,000, okay? That leaves $20,000 of non-exempt asset, okay? So the trustee is going to tell the person, hey, guess what? You like your car? Okay, you want to keep that car? But you have 20,000 unexempt asset there. So give me 20,000 bucks so I can pay creditors and you keep your car. It's the same thing with a house. If the house has equity beyond the exempt amount, they could do that too. Okay. Now most people file Chapter 7s with real property. They're not doing it for the purpose of the house. They're doing it for the purpose of other things. So for example, it may stop a foreclosure, but then they're not current on their home. And the problem is a lot of these loan modification people, what they're doing is they're playing that game they're on the line, right? They're saying file Chapter 7, don't pay your mortgage, and let the bank come to you and make a deal. Guess what? The deal doesn't happen in a lot of cases. And the night before, they're panicking, saying, oh, you know what? I tried. Well, what did you file? 7? Yeah, good job, dude. So then we file another case, or we have to go to do a lawsuit. There's different things like that. But yes, people file 7s, but it could be to avoid a lien. So if there's a lien on a property, which is beyond a certain amount, which is a credit card lien or something, because those show up in escrow, right? You're ready to close escrow, and this random stupid judgment shows up on the property for like 30 grand against like Citibank. You're like, where the heck did that come from? That means that prior attorney who filed the case never avoided the lien off the property. And that's why that's another reason they filed 7 because there's no equity, but they didn't get rid of the lien properly. You're supposed to file extra paperwork. You have to ask the court to remove that lien. I think that kind of answers your question. Okay. Now I lost my thought. Okay, where were we? Any other questions? Okay. So 7 is simple. The main one that is going to come up for all of you is Chapter 13, because Chapter 13 involves real property. And that's kind of what you guys do for a living, right? You sell property? I mean, isn't the goal to sell property? Isn't the goal to make commission? Come on, guys. I mean, none of this stuff is going to make commission for you. All this stuff is just going to help you realize that your client needs help. And if they get the help they need, maybe there's a deal at the end for you, right? That's all it is. I mean, so chapter 13, chapter 7 is liquidation. Chapter 13 is called the wage earner's bankruptcy because you got to have income to be in chapter 13. You got to make payments. And if you don't make those payments, your 13 turns into a chapter 7. Okay? So the most simplest analysis, if we go back to 7 and the car analysis where they say, give me $20,000, you can keep your car. You go to a 13 and say, okay, well, I'll give you $20,000, but I'll give it to you in a payment plan of 3 or 5 years. So you basically convert that asset that's not exempt and pay it back via a payment plan. That's all 13 is. It's very simple. But in the example I'm going to give you, I'll give you a little more depth on it. So people come in, chapter 13, what you're going to see is, before we get into how the case works, there's a foreclosure coming up on Friday. The client's going to call you, or call me Thursday night, because that's just what they do. Their hopes and dreams tell them, oh yeah, the night before I'm going to do what I need to do to file bankruptcy. They're going to call me at 4 p.m. and say, can you file? Yeah, I'll file. You know, I'll file it. I'll file it at 4:30. I'll file the case. Then we take that paper that says bankruptcy filing, and we give it to the trustee, the foreclosing trustee. They have to stop the sale. Once they stop the sale, then the sale will get continued and continued. And it cannot sell, although they set a new date for the sale, it cannot sell so long as the bankruptcy is pending. And it cannot sell unless the lender goes into bankruptcy court for something called a motion for relief of stay. Meaning they're telling the court, hey, Your Honor, we need you to lift the bankruptcy protection so we can foreclose on this house. It's not being paid. There's no value. It's underwater. So those are certain things. For your purposes, if you know your client's going to be foreclosed on, all you need to say is, hey, maybe talk to an attorney. That's it. Do not prepare their bankruptcy papers for them. So in this chapter 13 example, kind of similar to the last one, the assets are $50,000. Okay? The home has $400,000 in equity in it, but that's protected by the homestead exemption. Okay? And then on the debt side, they have $100,000 credit card debt, $60,000 medical, and $70,000 in missed mortgage payments, and a $50,000 car loan. Okay? So the goal of the Chapter 13 is, can a feasible Chapter 13 plan be put together, and can it be confirmed? So similar to a Chapter 7, you're going to go with your attorney, you're going to file the paperwork, going to file a bankruptcy. Maybe it's an emergency bankruptcy where you file it the day before, which allows you to file the extra documents to finish the bankruptcy. So you file your bankruptcy, you stop the foreclosure. Then what happens is the court's going to say, hey, you need to put a plan together. How are you going to pay these guys? With what income do you have? So we have to put a plan together. And the plan is going to include that there is a trustee in Chapter 13, but they're not as controlling as the Chapter 7. You're still in control. All they do is they kind of oversee things, but they are the ones that distribute the money to creditors for you. So for example, you have a car loan of $50,000 outstanding, and then you have $70,000 missed mortgage payments, okay? Plus you have $50,000 cash, which is not exempt anymore because you're exempting your home equity. And that $50,000 cash will be shared by the $160,000 over here. So these unsecured creditors will share in the $50,000 here. So if you add the $50,000 car loan, the $70,000 past due mortgage payments, and the $50,000 cash that's going to go to unsecured creditors, you have an outstanding balance that you have to pay through the plan of $170,000 plus interest, which comes up to $187,000. And that $187,000 will pay off your car. It'll pay the back payments on your mortgage, and it'll pay up percentages to the unsecured creditors like credit cards and medical bills, things like that. That comes up to $3,117 a month. That does not include your current mortgage and your current utilities or fixed expenses. So this is where reality comes in. Is a client going to be able to pay their regular mortgage and pay for the past mortgage and for their car and their lifestyle? I mean, they hope they can, but most likely they can't. So that's kind of where we put this plan together. 6 months go by and they say, hey, I cannot afford this. And if I go to a Chapter 7, they're going to force me to sell the house. So what do? Well, you know what? I have an idea. Sell the house. Okay. And the person who could help you with it is your real estate agent. They could sell the house. So what you would do is you would tell the court, Your Honor, they can't make the payments. But if we give it to a 7, if we convert to a Chapter 7, the trustee's going to sell it. And how much money are they going to get? They may foreclose. They may liquidate. They may not make me any money. So we list the property within the Chapter 13. You sell the property, get a court approval, and you get to get those funds. Well, the seller gets to get those funds. So that's what the 13 does for you. Questions? Okay. So did you have a question? Okay.
I have a question.
Tell me.
So
Oh, wait, hold on.
if it's in a,
You there?
if at the time of sale and they're in a Chapter 13 payment plan, does the seller have to pay the trustee for the payment plan at the close of escrow?
Well, the trustees paid on distributions, so everything that comes out through them and into escrow, they'll probably get a payout percentage on it. Yeah. Thank you. How'd that mic work out for you? Pretty good. Okay, so that's the 13.
Question.
So now,
Hello?
I gave you the basics. Now here's the fun part. The fun part of bankruptcy is how we play the game. Okay, and you didn't hear that from me. It's a game. It's all a game. So let's say, for example, your client literally just wants to stop the foreclosure and then sell the property and make the money. That's all they want. Okay? Chapter 7 and Chapter 11 cannot be automatically dismissed. The 13 is the only case you can go in and dismiss the debtor can dismiss themselves. They can do that without asking the court. 13 is the only one they could do that for. So what does that mean? That means, let's say foreclosure's on Friday, they file bankruptcy on Thursday. The foreclosure is stopped, okay? Then your realtor says, okay, I need 2 months to fix this property and get it sold. We file in May. So is August a hot time to sell? Or July? Probably July. Okay, so you file in May. July, you get the house ready to sell. You list it July 1st. It's sold August 1st. After it's sold, you dismiss the bankruptcy. What did the bankruptcy do for you? It basically bought them the time to clean up the property, sell it, and get it for top dollar. And that's what a majority of individuals are going to do. They're going to list the property because they can't afford it. But they don't want to stay in a bankruptcy. They don't need it. They just want time to sell their property for top dollar. And that's what individuals do. The bankruptcy ends up being about a month or 2 months or a couple of months. In fact, you could do a plan, make a few payments, sell the property, and shut the case down. So that's the strategy point of 13s. And I mean, I've done a lot of those where just get me the time to sell the property. Give me the time to sell the property. Let me get top dollar for it. Let me spend some money on the yard and pretty it up, and then we could sell it. And that's what happens. That is the benefit of the 13, that it gives you the ability to file and dismiss. Now, unfortunately, bankruptcy is going to screw their credit up. You know, if you actually go all the way in bankruptcy, you're going to get a screwed up credit. If you file a bankruptcy and dismiss it, it's still pretty bad. But I mean, screw the credit or make another couple $100,000 on a sale, it's up to them to decide. So that's kind of what happens in a 13. Chapter 11s are probably more complicated. They're technically for companies, but if the individual's debt is so high, meaning over like $1.5 million in secured debt or $400,000 or $500,000 in unsecured debt, they can't be in a 13 anymore. And the difference is a 13 could cost maybe like $5,000 to $15,000 max, and then the down payment to the attorneys are paid up front, and the balance of the attorney fees goes in a plan. It's very affordable. A Chapter 11 is not. A Chapter 11 can be $15,000 to $20,000 down payment to retainer to the attorney, and it's billed hourly, which is, you know, for my rate, $5.25 an hour. So it's billed hourly versus a flat fee on a 13. So individuals who can remain in a 13, it's much more affordable. 11s are completely transparent. Individuals got to shut down their bank accounts. They got to open new bank accounts. They got to describe everything with the property. It's just more intrusive of a bankruptcy because it's like a business. But again, it's based on high amounts of debt. And I mean, anybody who can stay out of an 11, it's much better. Yes, sir. Oh, hold on. I got to get used to this. Sorry.
I learned about a client of mine who completely has no other debts except the mortgage.
Mm-hmm.
And they went to a loan mod, and then they were not successful, and ultimately they filed Chapter 11 to force the lender to give them the refinance. And that was the case. So was Chapter 11 the right thing that the attorney did for that purpose? Because there's no other debt except for the loan.
Right.
But they forced the lender to refinance the property after unsuccessful loan modification. That's the question.
Thanks. Yep. There are times a lender will work with the borrower in a bankruptcy, and it's more successful. So sometimes what will happen is the model fail. You do the bankruptcy, lender's counsel reaches out, and we're able to put together a new payment plan, which takes care of the arrearages. The problem is that that modification or that refi is only effective so long as they stay in the bankruptcy and complete it. So they can't just get a deal and walk out. No. More likely than not, it's going to be a stipulation between the attorneys and the parties and say, look, I'll tell you what, we'll give you a catch-up payment of this amount at this rate, but it's only effective in the bankruptcy. So that could have happened too. So, but yes, you don't have to file. You can file for any reason. You can file just for your house. You can file for a car. You can file for a repo. You could file because of a lawsuit it's too expensive. There's many reasons. And filing just for a house happens a lot. They may have no other debt except their mortgage, which they've been fighting a loan mod forever. That make sense? Okay.
I have a question. Can you hear me?
Whoa, that's pretty cool.
Can you hear me?
I can hear something.
What's that? Hello, can you hear me?
I can hear you, but I think he's making it louder.
How about that? Can you hear me now?
He's gonna ask it in the chat, so it doesn't go over the recording, because I can't turn him up.
Okay. Can you guys hear me without this? Oh, they can. That sucks. I'm not feeling this mic thing. I wish I had one of those things.
Hello, can you hear me? Hello?
Where's the speaker where he's talking from?
Yeah, everyone is able to hear you. You can talk.
I can hear you. I'm going to stand by the TV. Go ahead.
All right, my question is, how often, let's suppose a client is in a bankruptcy and a need arises for a realtor. How often does the court give a referral for a realtor or an attorney? Are there lists within the court that you can get onto where you're used to in a case where they don't have a realtor?
So I think the question is there a list available with the court where realtors could be listed to provide services for bankrupt individuals, correct?
Yes.
Okay. So, no, there's no list for real estate agents to be provided to individuals filing bankruptcies. However, the parties in a bankruptcy that may consider a relationship with real estate agents or real estate professionals would be a trustee. And the way that works is if there's a Chapter 7, and let's say the individual loses the house, well, the individual can't keep his house because he can't come up with the equity payment, and the trustee has to sell the house to collect the equity payment to pay the creditors, then the trustee would have relationships with real estate agents. So there isn't a list, but if someone is looking to get involved with working with professionals in bankruptcy, then that might be an opportunity to do it that way. Kind of like estate planning. If you connect with estate planning attorney groups, you may have a relationship with individuals who would require the services. Does that answer your question?
Yeah. It's all set.
Oh, cool. Okay. Okay, so we'll lightly touch. I mean, I got like 28 minutes left, so I'm going to touch bases, and then at 11, if you have questions or want to throw me in the corner and ask me about anything, go ahead. Estate plan. Okay. Everybody hears about an estate plan. Okay, I'm kind of taking a backtrack before we get to the real estate transaction. So an estate plan is not just a living trust. An estate plan is decisions you make among members of your family or other individuals on how you want your estate to be distributed upon your passing. Okay? So when you purchase an estate plan from an attorney, you go to estate planning attorneys. They sell you an estate plan, or you go online, which I don't want to go there. But you buy an estate plan, and the estate plan, what it includes is a revocable living trust, okay, a power of attorney, advanced healthcare directive, a certificate of trust, and those are the documents that are going to be included, and a pour over will. So you have the core document is your living trust, and the purpose of that is to define and describe how you want your assets to be distributed upon your death, okay, and picking trustees and individuals to manage it. Then you have your financial power of attorney, which is what you give the banks to have access to the accounts, for your individuals to have access to the accounts, and then you have your healthcare directive to give the nurse or medical professional to deal with. You have a pour over will basically saying, hey man, whatever I've forgotten, personal property just goes via the trust. Okay, that's the simplest thing you're buying is an estate plan. I don't do estate plans. I get involved when somebody sues somebody in the estate, meaning the kids don't like the other kids receiving the money, so they sue each other, or someone, takes advantage of an elderly individual and the money gets taken. That's where I get involved. Estate plans are very, very specific documents, and I think my suggestion, if you're going to get an estate plan for yourself or get it for your client, deal with a law firm that specializes in estate plans, because those plans, the rules change, there's tax results, things like that. You want to get a firm that actually has a thriving practice in that transactional component. I'm a litigator, but those are transactions. So that would be the best advice I would give someone when getting an estate plan. Now, the estate plan's done, and behind the revocable trust is something called a schedule of assets. And that's where it lists the assets that belong to the settlors, the individuals who make the trust. Okay. Sometimes what happens is when an individual dies, the property goes to their kid or whoever they appoint as a beneficiary. But before that happens, the property is held in the trust. And that individual, that settlor who creates the trust, becomes the trustee of their own trust until they pass. So part of having an effective living trust or revocable trust is putting assets into that trust. And how do we do that? We title the property as trustee. So let's say the individual is, Mickey Mouse. So it'd be Mickey Mouse, trustee of the Mouse Trust or Disney Mouse Trust. That's what it would be held at in title. So when you go to title, that's what you'll see. What happens sometimes is individuals will go in and say, I want to refi my property, and they'll try to refi the property, but the lender is going to require them to take it out of the trust. And guess what? Time goes on, and they never put it back in the trust. So when that person passes, the property is not part of the trust because it was never property titled. Okay? So then everybody panics and says, hey, this has to go through probate, and probate's hell. Probate's hell because there's court involvement, there's huge delays, there's huge attorney's fees, and it just takes forever, which is obviously why a living trust is a benefit, because you have more control, you pick your trustees, there's not much court involvement unless something gets involved, but it's a private document, and you decide how you want things to work, or the deceased decides how things to work. So once that happens, you have a property that was never put back in the trust, the owner passed away, and the only option without a trust would be a probate. So then you go to the attorney, and the attorney files something called a Hegstad petition. And that attorney puts this petition together and says, hey, Your Honor, look, here's a schedule of assets. This says that property belongs in the trust. And this property needs to be put back into the trust so it can be distributed via the trust. Okay, and that's one of the issues you're going to see. So if you were to go to a client and they say, hey, wait a minute, let me see the title of the property. Something weird over here. I think you should see an attorney. Why is it not titled? What's going on? These are things they need to figure out before the sale. Because once you get to escrow, what are you going to be? What's going on here? Right? Tell me. Oh, wait, hold on.
Yeah, typically, when you refinance a property that's in the trust, the MLO, you have to inform the escrow and title to make sure after the refinance, the property is placed back in the trust.
That's probably more current because a lot of times it doesn't happen.
That's why, that's just always a practice.
Yeah, yeah.
If the loan officer didn't do that, I don't know.
Well, that's when they call me, right?
That's just the point.
Yeah, no, exactly. And, you know, loan officers don't do that at times. And that comes up, and that's and that's why attorneys are involved.
Just a clarification. I'm a loan officer myself. I work for Bank of America.
I've never seen you,
So
you must do a
when
good job.
we do a refinance, if the property is in the trust, we always request a copy of the trust.
Mm-hmm.
So when we close the loan and we put the property is in the trust, that's always the case.
What if they don't want to give you a copy of the trust?
We find out. We'll find out the title, if the property is in the trust, then we'll request a copy. If they don't give us a copy, we do not do the loan.
What if they give you well, the trust is a private document. Are you satisfied with a certificate of trust?
Well, unless they want to take the property out of trust, and then they sign the quick claim deed, and then we'll do the refinance, and we as is, not put the property back in the trust.
Well, but the question is, there's a document called a certificate of trust, which is a summary of a trust. Would you take that?
We do.
You will, right? Okay, that's what I thought. So that's the point, right? The trust is a private document.
In California, that's mandatory. Certificate of trust.
Yeah.
I'm an MLO.
Okay.
So I have a state planning authority.
Okay.
So if somebody refuses to accept the certificate of trust,
Mhm.
it can be held liable.
Wow.
That's a strict compliance. The certificate of trust is a legal document. They don't have to provide an entire copy of the,
Is that every lender in California?
they have to.
Wow. I wish I knew that.
Now,
'Cause-
some,
there you go.
members, depends on what type of loan you're doing,
Right.
they can request. But 9 out of 10, it's just a certificate of trust.
Yeah, that's the problem, right? I mean, these are rules we're all aware of. It's like when you go to a bank to open a bank account for an LLC, and they want an operating agreement. Do I really want to share the operating agreement? Or as an attorney, you're more protective, obviously, right? My job is like, okay, you got a trust, it's private. You got an operating agreement, LLC, private, but they want to see the signatures and know who's involved. So it's always kind of a negotiation. If they're not up on the rules, that's where we're suing the loan officers for fun. Yeah. Oh, wait, hold on. Got it. Okay.
Hi, thanks for the information. So as an owner, how can you provide a certificate of trust? Is it already in the package that you get from the estate attorney?
Right, so when you do your estate plan, I might not have said that, one of the documents is a certificate of trust that estate planning attorney should put together.
Oh, okay.
And that's just a convenient way to share the details of your trust without providing the full document.
A question from the chat.
I guess my question, before I forget, is the difference
Oh.
between power
Oh, sorry. Okay.
and the durable power of attorney.
So there's
Question I have is, a lot of people get confused.
yeah.
What's the difference between a POA, power of attorney, versus a durable power of attorney?
And there's also springing power of
And
attorney.
a spring power of attorney. Can you please explain that?
Well, the springing a power of attorney, there's a power of attorney that it's all based on effect. It either takes effect now, or it could come into play later after the passing. It just depends on how it's written, and those are the differences between the power of attorneys. It just depends how they write it. Most attorneys are going to give you springing power of attorney, but that's for the financial. The Advanced Healthcare Directive, sometimes what happens is attorneys have their own forms, but I would say, some of these hospitals have forms that they use, and there's also state forms. You might want to get that just more familiar to the nurses or when things come up. What's the chat question?
Question from the chat. So if someone made a modification about 10 years ago in which they were charged about 80 grand on their lawyer fees, they got a deferred 200,000 on payments, and today they owe, one second. They owe the same amount they owed 10 years ago, pretty much. Can they go to a real estate lawyer and fight the charge of 80,000 for the bank's lawyers? It was added to the deferred amount. After 30 years, the 200 grand kicks in and they have to pay it. My client asked, I advised to go see a real estate attorney, but he thinks it might be too late. Any thoughts on this?
Well, I mean, the key here is to go to the attorney to find out whether or not it's too late, because there's a statute of limitations, there's various issues that come up, and we need to find out when that claim, if that claim is still valid. and understanding the claim. So yeah, I mean, I would advise, statute of limitations is a general term. There's different things that could come up during a time period that may extend or toll the statute of limitations. So those are the things that they need to figure out with their attorney. Cool? Okay. Yeah, okay. So I'm going to give you an example, okay? I'll give you an example. This is my favorite example. It takes trust, probate, trust, probate, and bankruptcy all into one and a dead body. So this makes it fun. So currently, there's not too many bankruptcy judges left. Years ago, there were a bunch of judges, and a lot of judges I feel were friendlier to the people who file bankruptcy. These days, I feel they're friendlier to the banks. I don't know why it happened, but in this county, I've just seen that happen. So kind of going back to your point, right? Can they reject a bankruptcy, or can you just file it? They can file it. It may not be valid. They could get rejected down the line, but the point of filing, you press the button, it still gets filed. It still shows up, okay? So the foreclosure, was there a question? No, okay. The foreclosure was set right over here as a foreclosure, okay? This lady comes into my office, and she tells me, look, my mom passed away, and her house is going to be foreclosed on Friday, okay? And that's my house. I'm like, okay, it's your house. Are you on title? No. The house is your house. My mom wanted me to have it. Okay, well, that's great, but are you on title? No. Well, how's that going to help me, right? Okay, so I said, okay, what do I do? Can I file bankruptcy for a dead person? If you don't tell anybody, maybe I will. But I couldn't do that. I'm just kidding. So I didn't do that. So I said, okay, let's try something here. Can we file bankruptcy for the daughter and say in the bankruptcy that she is a potential she's potentially expected to receive the interest in this property? That is completely wrong. That is not a reason to file bankruptcy. It's not true. You can't do it. And can a dead person file? No. Can a probate file? No. So what do? I filed it anyways. Was that bad? It was totally bad. Was it wrong? It was totally wrong. But guess what? I filed it. So I filed the bankruptcy. It stopped the foreclosure because the lender didn't know what was going on. So I filed the bankruptcy. Then I go to the court. The attorney for the bank is yelling at me, tells me I'm stupid. I just smiled. Judge is yelling at me. But then the judge said, I'll give you 2 months. Oh, yes. So it turned out I got 2 months from that. So then what do? Okay, then I got a house that payments are defaulted, owners passed, but regardless, it's still not in the title of the daughter, who's my client. So what do? So now you have two issues, and there's no trust. So we have to go through probate, right? So what happens? The bankruptcy is stalling the foreclosure. Now, in no way would I advise anybody to do this. It just happened. It's a funny story, I'm telling you. But we stop the foreclosure. So that gives them that automatic stay. The automatic stay kicks in to stop a foreclosure. That's the trigger. It stays collection and foreclosure activities. Okay, now, how do we get the property in the title of the daughter? Okay, so she had to hire a probate attorney. The probate attorney goes to court, gets the letters of an authorization to probate. Probate started. The house is listed, okay? The house is listed and the probate's done. The house is listed here and it's sold right over here. I mean, not sold, sorry. An offer comes in that is accepted. What does that mean? That doesn't mean anything because without the bankruptcy court approval and the probate court approval, we can't do anything. So everything's like under the gun. So probate attorney had to run to probate court, get an approval for the sale. She got it. Great. I got bankruptcy court approval. I got it. Great. We were so happy until what happens? Escrow. Escrow happens. The body of lawyers in the back of, not you guys, the body of lawyers in the back of the office tell me, oh no, we don't like these orders. What? You want me to go back to the judge and fix an order? Good luck with that. Okay? So, escrow comes in, makes these changes. We have to go back to court and get the orders. But luckily, for some reason, the judge was cool enough. I went in there, made the change, and probate court made the change, and escrow accepted the orders, sold the house, and the bankruptcy got shut down. Client got her money, disappeared, never paid me. I think she's in Hawaii somewhere. I got screwed. But yeah. Well, you know, what else, I mean, as an attorney starting out, you get crazy. I had a guy who tried to kill me too. So you get crazy clients starting out. I had one guy, I digress, but it's fun. I had one guy, he comes over And I swear to God, when he was talking to me, I think his eyes were flipping back. He was super freaky. So he had like 4 bankruptcies, and I filed a 5th bankruptcy, which is completely invalid. Saved his house. It was great. And then he tried to kill me. So it was crazy, but it was really weird. But in this case, what happens is, so escrow approved the sale, right? Which is great. But what is the learning points from here? Okay, besides the fact that I played along with the on the line and stuff like that. But the key here is, how would I have changed the situation? Number one is, I think the real estate agent was smart. She was good. She knew probates. But I think her communication should have been a bit better, meaning she should have been the central focus of communicating with escrow and the attorneys and making sure everybody knew each other before I get to the last minute got an order to give to escrow, right? That team should have been put together before, okay? If that team was together before, we wouldn't have been worried about going back and getting a new order. So my suggestion, at least for attorneys, to get the order to escrow reviews it beforehand, so we're not wasting time. Because if we waste time, guess what? The buyer walks. Commission's gone. What's the point of that?
In terms of the orders, can you specify what specific wording you have in the order that escrow requires?
So I have my own language that I put into an order that I give to the judge. The judge approves it, it's good to go. The problem is, once the judge signs it, escrow may not like it. So you're better off getting that draft order to escrow beforehand and ask them, hey, is this going to be acceptable? If they give you the green light, then you give it to the judge. The judge will hopefully be okay with it, right? But it's being proactive in advance so these hiccups don't come up. These hiccups are where deals fail, right? Does that make sense?
Yes. Actually, follow-up, this is more like in the bankruptcy. Let's imagine that this house actually went to foreclosure and you were not able to save it, and there was a loan on it, but then there was a lien behind the loan. So if the bank forecloses and there's money left over from what the bank is owed, do they give that money back to the owner, or do they pay the lien, or do they just keep it?
Well, it depends. I mean, if you have a second on the property, they get paid. If there's money left, it'll go back to the owner.
No,
But good
this
luck
is a
getting it.
lien,
What
not-
kind of lien?
Like a
Judgment.
state lien, a judgment.
Okay, so they'll get paid from the sale.
Oh, they would?
They get paid from the sale, yeah. It's all the liens, right? First, second. But there's no guarantee they'll get all their money because the first will get all the money.
Oh, okay, so who makes the addition and subtraction? The bank?
Well,
The
no,
one that forecloses?
they'll foreclose, and then there'll be an accounting, I think an accounting provided, and they get paid from the equity or whatever's left after the sale, right? So it just depends on how it's calculated at that point. I don't know who runs that part of it, but any second or third, if there's sufficient equity, they're going to get paid. The difference is whether or not it's a purchase money, judgment, whether or not they can collect it from the owner. If they don't get paid, there's various rules on that component there.
All right, thank you.
Yeah, yeah. So anyways, this was the biggest issue for me, is making sure that real estate individuals, and I say this all the time, we have a growing population, guys. So if anything there is to learn about probate. Learn about trust. Don't give advice, but just learn how it works, because there are delays that could come up that you could stop to help you close this transaction. And I feel a real estate individual that knows just a background of these 3 topics, because just because NVIDIA's across the street doesn't mean people are going bankrupt. People are filing bankruptcy. People are losing jobs. People are passing. There are these 3 areas. If you have a general understanding, it's going to help you tremendously on spotting these issues and being able to close the deals when necessary.
So for the city of Stockton, utility bills, the tenant passed away. The utility bills, the city of Stockton said that it goes back to the owner. Can they put a lien on the property when they sell?
Can the city of Stockton put a lien on the property?
Because the tenant passed away. He had a major bill.
Oh, the tenant. Okay, so the tenant was using the utilities of the city of Stockton, and he passed.
Yes,
So can they put a lien? I don't think they can just, well, it depends.
on the owners.
Well, if the lien follows the property, if it runs with the property, then probably. But I think what they would probably do is maybe file a claim in the estate or probate. But again, it depends. I've seen some of them follow the property.
Right.
Like I have one right now in Salinas, $790,000 bill, utility bill, and it just sticks with the property.
With the property,
Hit the
okay.
property. So I don't know if that's the same case, but I think it might be. And that sucks because if a buyer comes in, good luck.
So the buyer or the owner?
Well, the buyer of the property, the owner, it doesn't, I don't know if it goes to the owner directly. It'll go to the property. So if the owner still has the property, it's on the property.
So can they put a lien and then stop the stop the escrow? Like, can they put a lien on it, and then when you go to escrow?
Go to sell it, it'll
To
show up.
sell, yeah. Can,
Usually collect or ask for, like Stockton in certain areas where they have specific, like Monterey.
Yeah.
You ask for a demand in the middle of escrow.
Mm-hmm.
It has to be paid. Like in this case, it was the tenant and not the seller, then they would indicate to us who is going to be responsible to pay it, or if it's going to be forgiven by the utility company.
so is
So
it
we
gonna-
still have to order it.
You still have to order it. Is that
Yeah.
going to slow the escrow? Like,
Well,
say,
it's just like any other lien. It would be another payoff. Like if there was a loan, we would just order that just the same during the transaction.
Okay.
But if that's something that you already know beforehand, that's probably something you should want to discuss with your escrow officer, so you know if it has to be paid or not in advance.
Okay, so escrow, okay.
Yeah, that's escrow question.
Okay.
It'll slow down escrow.
Can I ask a question?
Yeah, sure.
From your experience, is there a course that, that agents can certify themselves in probate process and become like probate expert? Because, if you haven't done probates, how can you start if the attorneys want, to you to show experience? So it's kind of like an obstacle to overcome.
I thought SCORE provided those classes. Yeah, I think there's a probate one. Yeah, I think there might be a probate. I mean, yeah, I think it's good to just have that understanding. I think SCORE has it. Yeah, yeah. Is it? Who's teaching it?
That would be Paul Horn.
Oh,
Thank you.
the same attorney who did it all the years.
Oh, the SCORE. I mean, okay, yeah, yeah.
Is there a way to find out who the attorney who handles certain property? Like if it's in a trust, like the brother, like the sibling, they don't talk, and
Oh, yeah, it's tough.
Is there
You
a
can't,
way to
you
find
can't
out?
find out unless something is like you receive a notice or something that something's being administered or some kind of proceeding. If you're not going to talk to the individual, then you have to wait till you receive some kind of correspondence.
oh, only correspondence,
Yeah.
like the brothers and sister, they don't talk. And
Yeah,
the
there's-
sister handles everything.
Exactly. So you got to ask the sister. If they don't talk, how are you going to know?
I know.
Right?
She purposely did. I think she didn't put his email on there or the
Yeah.
wrong email, so purposely he won't get the info.
The unnecessary drama that happens in family disputes.
Yeah. So I don't know how how to help him.
Well, they could they can hire an attorney to contact the sister and say, "Look, I need to talk to you," or send them a letter, and then she gives it to her attorney and they
Okay.
start talking.
Okay.
That
Hopefully
could.
that.
I've done that. I've threatened to sue them, and then they get their attorney involved.
Oh. Okay.
Yeah.
Okay.
Yeah.
Okay.
Also, in this sample here, the one thing which was interesting was we find out that mom who had passed had killed her boyfriend, and he was buried in the backyard. And then her current boyfriend, I think she killed him in the car. So the big issue was, what's the value of the property? Does the death in the car apply, or is it in the backyard? So the FBI took the dogs over and they looked. But yeah, that was pretty interesting. That's one of my highlighted screwy crossover cases. Okay, how are we doing? Okay, I think we're at 10 o'clock. I'm open for questions. I mean, you can ask me anything you like. I mean, if I don't do it, I'll tell you. Online? I try not to put the code sections and too much law in there because it just gets like, I'd rather just keep it open for samples.
Okay. I got one from earlier in the chat,
okay.
real quick. So the parents did a refinance and added the son on the title. Now they would like to have an estate planning. Does the son need to do a quick claim deed ignorer or the parents to prepare their estate planning?
Wait, what? Say that.
Added the son to title,
Uh.
and now the parents are doing their estate planning,
Okay.
and they want to know if they can take their son off the title by.
Oh, well, no, don't ask me that. You need to get that estate plan with that attorney and figure it out. That's, that could give you the completely wrong advice and everybody could be screwed. No, you got to get the estate plan attorney involved for that one. What's that? Yeah. There's exactly tax applications. There's huge issues that come up, which I can't give you a straight answer on that. She already knows the answer.
All right, thank you. So a question in probate. When you're trying to establish a listing price for a property that will be going up to sale under probate, and you've got three parties, you've got the occupant and two beneficiaries, and they're not really speaking to each other, and they're interviewing different brokers to sell this property. What would be your best approach in terms of coming up with a value? How can you come up with a value that meets all their expectations? And once you are in escrow, are you automatically having to do the probate approval, or can you just close with the administrator agreeing to the contract?
So that question, although sounds simple, it's not, because that's one where it'd be suing each other in court, and there's disputes there because you have three parties that don't talk. So for that one, we'll need more information. We could sit down and chart it out, but it's not. The problem is when you have the family members that are disputing already, it's like I don't think we'll even get there yet, right? So that's kind of, so we can talk about that after. Or we can, yeah.
Thanks.
Well, if nothing else, oh yeah, there you go.
Can you touch on the transfer of death deeds? Because I've seen and read some of that versus probate.
Transfer of debt. Transfer of debt, the deeds?
Yeah, the TODs.
Well, there's different things that happen, right? You can even have, like, for example, you can have a bank account that says, if this happens to this person, that just goes to somebody, transfer upon death. Sometimes they have it where it'll go via the trust to that same person. But transfer of death on real estate, do you guys see that a lot?
Yeah. People are doing it because
Yeah.
it's cheaper than going to get a trust.
Right.
But you don't get the same benefits.
That's the thing. I've been seeing that happen, but I've been looking at it going like, what are you guys thinking? You're just missing out like 90% of what's important here. So I guess that they do it, but the problem is people are finding ways with AI and different things to find cost-effective approaches. Although they might work, I think it's resulting in more litigation for us. It's, I'm not complaining. It's a pain. Okay. Thank you guys, and I hope it helped.